Finance, law relating to insolvency. My name is Giselle Dukuze. I'm the Legal and Compliance Officer at Rwanda Finance Limited, and I'll be moderating this session. We are pleased to have you today in our 6th session of Fired Up for Finance series. Today's discussion will be around the new law relating to insolvency of 2021, which effectively repealed the old law of 2008. This law is one of the laws that has been amended in line with the Kigali International Financial Center, which will be discussed by our panelists as well. We have with us today a wonderful panel. We're composed of practitioners and regulators who will shed light on the whole concept of Kigali International Financial Center, the purpose of repealing this old law to this new law of 2021 that we are going to discuss about. And also they will be talking about, our panelists will be talking about the insolvency proceedings for both local and foreign entities, the role of insolvency practitioners, and any other new aspects brought by this new law. I will start by introducing our panelists. On my left, we have Kaiji Leon Kajuga, who is the Business Facilitation Division Manager in the Office of Registrar General at RDB. The position he occupied after serving in different positions at RDB, including the Legal Division Manager and Strategic Investment Legal Analyst. Leon is a business lawyer holding a master's degree in business law and also holding a postgraduate diploma from ILPD. Mr. Leon served in different government institutions, like in Medicofin as a procurement specialist, and in the office of the Ombudsman as legal advisor in the department in charge of corruption, fighting against corruption. Thank you for being with us today. You're welcome on the panel, Leon.
Thank you.
Right next to Leon, we have Isaac Bizumureni, who is the managing partner at Lex Chambers, one of the leading law firms in Rwanda. He has been in that law firm for over 14 years, where he practices corporate, intellectual property, commercial advisory and litigation, arbitration, corporate insolvency, and business turnarounds. Isaac holds a master's degree in international trade and commercial law from the UK, and also he holds a master's degree in human rights and a postgraduate certificate in international business law from London as well. Isaac is a member of International Association of Insolvency Practitioners. He's also a member of, he previously served as, been a member of American Bankruptcy Institute, and he's a licensed insolvency administrator in Rwanda. Mr. Isaac is also a member of, he's an arbitrator member of the London Chartered Institute of Arbitrators for the last 8 years. He's also a member of the panel of arbitrators at Kigali International Arbitration Center and a member of African Arbitration Association. You're welcome, Isaac. We're pleased to have you today.
Thank you.
Last but not least, we have Anthony Mukulu, who is the Chief Legal Officer and Company Secretary of Rwanda Finance Limited, and he is responsible for legal advisory, regulation, and compliance. Anthony is a seasoned lawyer with vast experience in finance, dispute resolution, business transactions, trade policy, and trade law. Anthony, prior to joining Rwanda Finance, he worked in the Ministry of Justice in the Office of the Attorney General for over 10 years, where he rose to the position of Senior State Attorney. Anthony has served as board member of the Kigali International Arbitration Center and was the chief legal expert on the Rwandan team, which successfully negotiated African Continental Free Trade Area Agreement. Anthony holds a master's degree in international trade policy and trade law. He is also a practicing advocate and a member of the Rwanda Bar Association. Anthony, you're welcome on the panel.
Thank you, Giselle.
Yes, welcome to our panelists, and I also welcome our audience, our viewers who will be with us today for close to 2 hours session that we are going to have, and we would love this session to be very interactive. We'll be receiving your questions and answering them towards the end of this session, and you can be typing your questions through our different social media platforms. You can use Twitter, you can use this YouTube, we'll be answering your questions toward the end of this session. Without further ado, I think I will start with you. Allow me to start with you, Mr. Anthony Mokolo. Anthony, when I was introducing this session, I mentioned that this law was amended in line with amendments that were done by in line with the Kigali International Financial Center. Please inform our viewers what the Kigali International Financial Center initiative is all about and the reasons behind its establishment.
Yes, thank you, Giselle, and good morning to our viewers. So the Kigali International Financial Center is an ecosystem of different financial players, and if I can just give you a background to it, we have the Vision 2050 as a country, and the target, among others, is to have Rwanda as a high-income economy. Now, to achieve that target, there was need as a country to increase the financial sector contribution to GDP. As we stand today, we have 2.4% contribution to GDP. And where we want to go in the Vision 2050 that I've mentioned, we are looking at having that contribution increase to 11.8%. So to achieve this, in 2017, the cabinet undertook a decision to establish Kigali International Financial Center. And for this to be achieved, Rwanda Finance was established as an agency to promote this center. So it's important to understand that to achieve the 11.8% contribution to GDP that I've mentioned, it's important that from now to 250, we have more than a tenfold multiplier to per capita income. So when you look at these figures, it's important that we have in place the legal framework. For example, we are referring to the law relating to insolvency. It was among the laws that was amended to achieve this target, among other investment vehicles, to mention but a few. So if you look at major financial centers, for example, if I give an example of Singapore. Singapore today, the financial sector contribution to GDP is about 14%. If you also look at Mauritius, it's about 12%. So you can see the reasons why we are aligning close to those numbers. And again, financial centers, though they provide the requisite infrastructure, what we are looking at here are the inflows, the financial inflows. It's important to have alternative sources of funding. We are all aware that in the times we're in, it's not enough to rely on a country's savings. It's not enough to rely on debt. It's important to also look at equity. So when we're establishing Kigali International Financial Center, we wanted this to be a hub that one can come and invest both inward and outward. So we are looking at the continent. You can use Kigali as a hub for your holding companies. You can structure your funds and the different financial structures that you need. So we are open, and again, it's also important to say that whatever we are doing, we are aligning it with international best practices and compliance, and again, leaning to economic substance. So these are all core principles that as Rwanda Finance we are developing. And again, you can't have a financial center without looking at the upskilling. So those are areas that are enabling factors to ensure that this financial center of Kigali International Financial Center is up to speed, efficient for all investments. Thank you.
Okay, thank you so much, Anthony, for sharing the background of Kigali International Financial Center, for shedding light to our viewers why it was put in place to increase the contribution of financial sector to GDP, and also that we won't reach there if we are not having a favorable legal framework, and which is why we have now today different amendments, including this law relating to insolvency that we are going to discuss today. Thank you so much, Anthony. Now, my second question goes to you, Leon. Rwanda Development Board, where you work, is a custodian of the insolvency law. So I would like you to explain to our viewers the key objective of this insolvency law, now going deep into our main discussion of today.
Thank you, Giselle. I think before I respond directly to your question, what is the key objective of insolvency law, I have to explain why it has been established and what is the scope of this law, so they can better understand. First of all, this law has been established. This law itself establishes the proceedings in order to settle issues arising from insolvency. And that is for companies, partnership, and individuals. And I would like also to explain for our viewers, first to understand when we say insolvency, what does it mean? Who is in a state of being called insolvent? Someone, a company, an individual, or a partnership is in a state of being called insolvent when that company, that person is not able to pay the debts due. For example, you have a loan in a bank, let's say 100 million, you have to pay back 2 million per month. You are not obliged to pay the 100 million at a go, but every month you have to pay 2 million. When you are able to pay, even if you don't have 100 million, you have 5 million, but you can pay on a regular basis, you are 2 million, at the end of the month, you are not insolvent, because you can pay on the debt due on at the time you have to pay. Every month you are paying. Now let's say after 5 months, you are not able to pay. At the end of the month, you can't pay the 2 million. 1 month, 2 months, you are in a state of being insolvent. That is one criteria. A second criteria, your asset, your liability are higher than your asset. Someone who is in that situation, we can call that person being insolvent. And now, people, your creditors, they are coming, they want you to pay back your loans to all of them, and they are coming together. Now, sometimes there are issues. Who are facing those issues? On one side is the creditor, and on another side is the debtor. That is why the insolvency law is there to put mechanism in order to put structures which can settle those issues. Which means when you are insolvent, the law provides how it starts, who can start the processes for someone to start to be qualified as insolvent, and how it can be done. The law shows the processes from the start up to the end. And the key objective is to help creditors and debtors to get their issues related to payment well structured. That is why in the insolvency law provides two principal mechanisms. First, the number one, which is the ideal, it's rehabilitation or reorganization of a company. You are not able to pay, but your business is still profitable. Maybe you have bad managers, you are not well managing your business, or some debtors have preferences. They are paying some creditors, they don't pay others. Whoever is interested can introduce a case in court and request that company be declared insolvent, but with the aim to reorganize, which and an administrator in that case will be appointed and will be the one to manage the company on benefit of both creditor and debtors. And we'll try to see how the business can be revamped, so that in that way the law provides the mechanism on how the payment will be stayed in order to reorganize first the business and then pay back the loan in a smooth way. That is number one. Number two, if the business, I may say, is you can't revamp, you can't reorganize that business, you have to go to second step, which is the worst scenario of liquidation. The liquidation, a liquidator will be appointed, and the main objective of liquidation and the task of the liquidator is to look for all assets of the debtor, put them together, and at the end will be one of the mechanism is to sell those properties, and from the proceeds they will be paying all creditors in equitable manner. It doesn't, to pay them in equitable manner doesn't mean to pay all of them, but to see who are the priority, who has to be paid according to what the law provides. And in simple words, this law is there to put mechanisms, to put structures to help people to get their loan paid through insolvency proceedings. Thank you.
Thank you so much. Thank you so much, Leon. I think for our viewers now that we are getting into this law, you've given us the overview of this law, like you've given us why this law is needed in doing business, in why everything with a start, we also have an end, and we have good and bad days. So even the laws must be there to protect and or to give a clear line, a clear procedure of how also those bad days can be handled. Thank you so much. So, Mr. Isaac, let me get to you now. Leo was saying different concepts, and he was just mentioning those concepts, and I would like you to explain to our viewers, as an insolvency practitioner, the difference between insolvency, liquidation, and bankruptcy, as the concept that Leo kept on mentioning.
Thank you, Gizelle. Well, I would, to start with, I would say that, insolvency in the law, that word becomes a technical word. But in English, it will apply to all conditions of either a company or a natural person being unable to meet his or her financial obligation towards third parties. That situation, in ordinary English, is called it is an insolvency state. But again, as you asked, insolvency, the difference between insolvency, liquidation, and bankruptcy. Let me start with bankruptcy. Bankruptcy is a term that is applied to an individual person. When an individual person is technically unable to pay or to meet his or her financial obligation towards the third parties, that person, in ordinary language, is said to be bankrupt. But from legal perspective, a bankruptcy is a court order. For a person to be declared to be said to be bankrupt, there must be a court order that declares that this person is bankrupt. Liquidation, on the other hand, this is the death This is the burial of the dead, bankrupt, or insolvent entity. It is the last stage of life of a company, and what takes place in liquidation is that all the assets of the company are recovered by the liquidator, and they are sold, and the proceeds from there are distributed to the creditors. If there is a balance, the shareholders will get residues, or what we call surplus. But the liquidation, I would say, is really that last stage. It's the last air to breathe of the company. Insolvency, as I said, insolvency, it is a process under which, as Leo said, first of all, it's a state. There is solvency and insolvency. Insolvency is a state where a debtor is unable to meet his or her financial obligations. And but when we say to meet his or her financial obligation, there's an important element that is on time. If you are unable to, as Leo said, that if every month you have to liquidate your loan on 2 million every month and specifies the date, that specifies date is the due date. So when you are a company and you are unable to service your debt on a due date, you can be said under the insolvency law to be in a state of insolvency. You are financially distressed. However, there is a possibility that you can fail to meet the due date to settle your debt when actually your balance sheet, all your assets are much valuable than the liabilities that you have. So in insolvency, we have what we call cash insolvency and balance sheet insolvency. So the cash or liquidity insolvency, that's when you do not have enough cash flow to meet your financial obligations. Balance sheet insolvency, that's when your assets are not, the value of your assets are quite low than the liabilities that you have. So that state is called, in those two states, you are already insolvent technically. So insolvency is that state of financial distress. Liquidation is the last stage of survival of a company. Bankruptcy is a court order declaring an individual person to be completely bankrupt, is unable to discharge his debt.
You mean that what they have in common is that a state, a company for insolvency, and for a person in bankruptcy, a state where the debts are due and they can't be paid, is the person or the entity is unable to pay.
Exactly.
So maybe a follow-up question, as you mentioned that insolvency is a process, what are the grounds for commencement of that insolvency proceedings, and who can file an application to start the insolvency proceedings?
Yeah, thank you, Gisela. Once again, the grounds for commencing insolvency proceedings. One is that, which is very much common in practice, is that you are unable to meet your financial demands on time. When you are unable to meet your financial demands on time, or financial obligations, as paying debts, for example, you cannot pay your employees on time, you cannot pay your loans on time, you cannot pay your suppliers on time, that you have to, you are already it is enough ground for commencing insolvency proceedings against you. But apart from that, from the balance sheet perspective, an auditor can, during his or her auditing exercise, he can look at the value of the assets and the liabilities and even recommend to the board that this company is under the balance sheet test, it is insolvent. And if you keep operating, you are going to increase the risk, and therefore we recommend that you commence insolvency proceedings or find other ways of restructuring the company. So from an auditor can recommend to the board, but he doesn't institute, and the board will recommend to the shareholders. We'll inform the shareholders about the state of the finance of the company under the balance sheet. And at that time, when those two grounds are sufficient, then we have, the law provides a list, about 6 types of interested parties who have the right under the law to commence, to institute proceedings cases. But I want to correct that the law does not specify that for commencement of insolvency proceedings, those 2 solvency tests must be satisfied. Either one of them. If your assets are still of higher value than the liabilities, but you have a problem with cash flow, then the insolvency proceeding can begin. It can begin in the sense that some types of business, the nature of the business, part of the assets cannot be liquidated to settle the cash flow problem without killing off the entire business. For example, if you are in telecommunication and you have your infrastructure is much valuable, but you don't have sales, and yet you have enough, higher liabilities like staff whom you have to pay, but because of competition, you don't have sales. Maybe MTN is making much more sales than Airtel, but Airtel has, as an example, maybe has very good, very rich infrastructure, antennas, and all those telecommunication infrastructure. So that problem cannot be resolved. The cash flow cannot be resolved by liquidating or selling off the antennas, the towers, in order for you to settle the debts. If you sell them off, you already create the business. So one solvency test can justify any interested person to file for insolvency against the debtor. Now, who can do that? Who have that right? There are about 6. The first one, and the list is not in order of priority. We have the creditors. The creditors, those are people who are owed by the company, and their payments have become due, and probably they have been patient, but in the assessment, they think that you are not able to pay. So we have the creditors, we have the directors of that company, all one of them. If the directors acting in a corporate, in a collegial administration, that is, if the body cannot agree to file for insolvency, then one of them is empowered by the law to file for insolvency. The other one are the shareholders themselves. So if the board has, if if the board has submitted the annual report, the financial statement to the shareholders, and in the shareholders meetings, they make assessment, they find that the company is technically insolvent, they can file for insolvency. The other we have the regulators. The regulators we are talking, we have regulators like the central bank, which regulates the financial sector. We have Rwanda Utility Regulatory Authority, RURA. It has also that powers. I'm giving examples. So the law does not specify, but say regulators. So if there is any regulator who's regulating a certain sector of business, and in their assessment, in their monitoring, they find that this company is financially distressed, they can file for insolvency. The other rights, people have rights. We have the Registrar General. The Registrar General, as Leo earlier said, and even as you said earlier, is the chief custodian of the insolvency law. Not only insolvency law, but also of the custodian of the company's affairs. So the Registrar General, upon his or her appreciation of the company's state, he or she has the right to file for insolvency against that company. Remember that under the law, under the company law, every company has to submit or file annual returns to the Registrar General's office every year. And so it is from those filings that the Registrar General can make an assessment, or he can even receive information from creditors or whoever, and then he can exercise that right to file. But when you are talking of insolvency, the right to file for insolvency, that is taken up or is filed in court. But as probably we will see, there's also another channel where the process can start with the Registrar General. I think that's what I can say on your question.
Yeah, thank you so much, Isaac. I think it's very clear now. We know what insolvency is, the proceedings, and who can start those proceedings. I think now we can go to new aspects that are brought by this new law, now that we've covered the whole overview and the procedures of this of insolvency proceedings. And I'll get back to you, Anthony. Among the new aspects brought by this new law, we have cross-border insolvency. And I would like you to speak more about it to our viewers.
Thank you, Giselle. So with the cross-border insolvency, this is one of the key amendments that was brought about as a result of having Kigali International Financial Center. So if you look at how the previous law was, it was more of a territorial jurisdiction. So as I started telling you, the structuring and investments that we are looking at having into Kigali International Financial Center, using it as a springboard or hub to invest in the whole of the continent, it's important to note that some of these structures, like holding companies, will also have other business entities all over the continent. If you look at some of the new structures under the company law, like protected sale companies, you may have the core here and you'll have the different sale entities all over the continent. So now the question comes, what happens if insolvency is instituted not only in Rwanda, but also in other jurisdictions? That's why it's called cross-border. You should have answers to that. And of course, in any market economy, as my colleagues alluded to, you have companies operating well, but you also have companies that will have to exit. So the other business aspect that we are trying to echo out here is to say it is one thing to facilitate entry, but it's another thing to ensure that exit is smooth, because it has a spiral effect on all players. You have people who have financed these projects, what happens? So you can't look at one side and you look at the other. And I think that's the biggest gist for our viewers, to say we don't look at only entry, but we have to make sure that the exit is smooth. And again, this is in line with IMF principles that they look at in jurisdictions, the ease of doing business. They also look at insolvency aspect. So as I mentioned, given the fact that many entities will use Kigali International Financial Center as a place for domiciliation and then use that to invest in other regions, it's important to say what rules apply, because again, if you have a law that does not provide for that, it would be a problem. Now, when you look at cross-border insolvency, you can see, if you make reference, for example, to the Unicitro model law on cross-border insolvency, they highly promote this. So if you look at the options left for jurisdictions, one, they can look at the territorial principle. Do you look at basically what your laws provide, or do you use the universal principle and apply such a model law into your system, or do you bring a hybrid to mix the territorial aspect and the universal aspect? So if you look at our current insolvency law, it has the hybrid. We remain with the territorial, but also bring about the universality to ensure that we facilitate exit of business. So here with cross-border proceedings, one has to know what happens. If there are foreign proceedings in another country, what happens to proceedings here? They may be concurrent even. Or there are proceedings that have been instituted in Rwanda. What is the impact of the assets of those companies in those other countries? And again, when you refer to cross-border, it's important to also bring out the component of foreign representatives. Will foreign representatives in the foreign proceedings be recognized here? Can creditors in those other jurisdictions participate here? What about foreign authorities? How will the different courts coordinate? So you see, all this is brought in the this cross-border insolvency, and it was added in to ensure that we have answers to this. And again, one of the guiding principles, in the past you'd find the principle of lex fori, where the claim has been instituted, being the cardinal driver to where the proceedings will be. But of late, you see the principle of lex situs, where to say where is the center of the main interest. That is the cardinal principle that I also wanted to bring out. So in cross-border insolvency, it's important for our viewers and practitioners to know that what is held high is the center of main interest. It's important as a guiding principle to ensure that these matters are arranged in a sequential manner. And again, it's also important to know the aspects where you can have the main proceedings and the non-main proceedings. How do you merge that? How do you move forward? So all this we have provided for it in the law. And again, it's also important to know what would be the effect of recognition of these proceedings. Definitely, for example, if there the center of main interest is in a foreign jurisdiction, our courts can be seized and an application made to recognize them once they do. Some of the effects would be to stay, for example, the transfer or encumberment of the assets here. All these aspects are also covered. So on cross-border insolvency, we believe as a financial center we are answering that. We are one, ensuring the predictability of our investors, and then bringing clarity to what we are doing. It's very important, so they should be comfortable and come and invest in Rwanda, because our legal framework provides for all this clarity. And again, with an exception that I wanted to bring out on cross-border proceedings, is to say, with all these principles, there's always the element of public policy, to say in deciding whether to recognize. Our courts will also look at aspects of public policy if what they're doing does not impact public policy. So there is that exception, which is a generally accepted principle. Yeah, thank you, Giselle.
I think it makes sense a lot, because if we're attracting investors and we're positioning Rwanda as a financial hub, we're facilitating investors to register. We should also have smooth way of exiting and a cooperative way with a clear way to deal with different jurisdictions. Yes, thank you so much. Maybe a follow-up question, not a follow-up question, I'll get back to you, but Leo, I will maybe ask you from what Anthony was saying of foreign main proceedings, if you can maybe talk more about that and their effects, and as we are lucky to have you from RDB, maybe if you can tell us about the impact, its impact on investment.
Thank you, Giselle. For me, it will be easier because Anthony has explained more about what is cross-border insolvency. I'll not go back into details, but we have to know, as Rwanda, we have Kigali International Financial Center. We'll be dealing with multinational companies. Multinational companies means companies which are registered in more than one countries. You are a company, let's say, registered in Tanzania, and you open a subsidiary in Rwanda. You are a multinational. You will be dealing with clients all over the world. You have a company operating in several countries. Now when it comes for insolvency, let's say the example for a company registered in Tanzania and in Rwanda, and that company is declared insolvent, but is declared insolvent in Tanzania. As Anthony earlier said, our law, as a principle, we have the territorial competence. We will not go in Tanzania and use their laws or their court judgment as a principle. But with cross-border insolvency, the law provides mechanism in which an insolvency or bankruptcy order from a foreign country can be executed in Rwanda through our courts. Now, as a country which want to be a financial hub, we want to promote investment. We want to attract more investors in Rwanda. We need to have a legal framework which allows those people to be comfortable and to know when there is a case of distress of companies, they want to get back their loan paid. Even if the process started in a foreign country, it can be implemented in Rwanda. That gives confidence to our investors, and it is one of the incentives to attract more investors. Because when a insolvency proceedings has started in a foreign country and you want to come to implement it in Rwanda, you have the same rights, you have the same mechanism as if it was started in Rwanda. For example, when in case of reorganization, when we start in Rwanda, we start the process of, you have introduced a case in Rwanda, in a court, with requesting for insolvency, to start the insolvency proceedings with aim for reorganization of a company. One of the remedies, one of the conservatory measures in the law, all claims are stayed. You can't start the process of recovering your debts when an insolvency process has started in a court with objective of reorganization of a company. That will apply if a foreign, let's say a foreign court order to reorganize a company has started and you introduced it in Rwanda and it has been recognized. The mere fact the process has been recognized, the payment, the claims on that particular company having assets in Rwanda will stay. That is an advantage, that is an effect, and that is one of the, what I was saying, it's a kind of incentives for foreign investment. I think anyone can add more, but for that is the main advantages, one of the main advantages, because when we recognize a foreign insolvency proceedings, we treat the same way we are treating the ones which started in our local courts. Thank you.
Much, Leo. I think it's very clear. Yes.
Yes.
So add an element to the question raised to Leo. So one of the key impact areas to investments is the low cost of doing business. That is one of the areas I know there is no entrepreneur that goes to something into a business or invest into a business without also being guided with numbers. So if you provide clarity, because here we're saying we're answering the questions of cross-border. Before you would have, let me say, the company would be here and have other establishments in other 3 jurisdictions. You're hiring lawyers in all those 4 jurisdictions. It increases your cost of doing business. So that is an element that I wanted to emphasize because of clarity and saying, okay, there are guiding principles, center of main interests and all this. Then definitely your cost of doing business is narrowed down because there's clarity. You don't need to move around the different jurisdictions to identify how you should proceed when your company is going into insolvency. Thank you.
Thank you so much, Leon and Anthony. I think our viewers are also getting, they are really understanding this insolvency law and its impact on, and this cross-border insolvency that we are talking about. If you had to, previously, if you had to institute to start court proceedings in each, if you're maybe doing business in 5 countries and you have to start insolvency proceedings in each country, to be costly, and maybe if you have the impact, the purpose of those proceedings is to reorganize, as Leo was saying, that will be costly, and now it's flexible. And I think for investors, they will always like a favorable environment where legal framework is very favorable like this. So it's important for our viewers also to understand this and to know why this new aspect was brought in this new law. Thank you so much for explaining this to our viewers. Maybe if I get back to you, Isaac, among the players in the insolvency proceedings, Leo has previously mentioned an administrator, and I would like you to explain to our viewers who is an administrator and his or her roles and duties during the insolvency proceedings.
There once again, yeah, the administrator is a professional in the field of insolvency administration, and he or she is regulated by the Office of Registrar General. The license is annual, and there's always application for renewal. So we have insolvency practitioners, but we also have chief insolvency administrator. The chief insolvency administrator, I think we said earlier, is a registrar general. And then insolvency practitioners, those are the practitioners listed in accordance with their expertise. And in that area of insolvency, these are the people who will administer the insolvent company or an estate of a bankrupt individual. You see, as you were asking questions, what happens is when a company is in a state of insolvency, you know, that state raises a high fever to about 150%, is it degrees Fahrenheit, to centigrade, to the creditors. There is a really very high, fever, and everyone is there is a development of anxiety at that moment. And actually, as they was said, one of the objectives of the insolvency law is to try to manage that fever, because from an ordinary perspective, when a person dies, people cry. They comfort up to the burial time of burial. There is no hope apart from these religious prophets who say they can resuscitate, they can bring back to life of that dead person. But in a company, when the company is in a state of insolvency, it doesn't, there is still, we say that this company is in, is intensive care. When a person is intensive care, is not declared dead, there is a possibility of this person coming back to normal life. So the same way in the company, when a company has entered into insolvent state, is still intensive care, and it requires this expert practitioner to try and study the challenges, the problems that this company faced that brought it into this stage of intensive care, so that he can see how either it can come back to life, continues the business, and be able to pay the debts. Or this company, according to the analysis of this expert, insolvency expert, it can recommend to all the creditors, say that I have examined this company with very clear these diagnosis tools, and this company cannot come back to life. And so as such, we will proceed, give it a decent burial by way of recovering all its assets, putting them together, finding the way we can give them the best value to dispose them, and then we share the proceeds. So one of the key objectives of this law is actually to manage that crisis, because as opposed to when to the death of a natural being, when people are mourning, in companies, the tendency is for creditors to come and grab. And so when they come to grab, there is a likelihood that one with big muscles will push away, the rest, the weaker one, and then he will take the rest. Yet, as I said, the expert, the insolvency expert, once or so, even in barrier of this company, that there is a fair treatment in terms of distribution of the proceeds, so that there is at least one. We have the lenders, the creditors. If they are secured, basically under the law, they take precedence. When they take precedence, that they need to be, this insolvency practitioner needs to protect their legal rights, so that the other grabbers will not prejudice their rights. So the insolvency practitioner or administrator, in that way, as I would say, is there to manage this crisis in a professional way and sees that the process goes smoothly, ways in cause satisfaction to everyone in accordance with their rights. So this, how does this practitioner do that? Upon appointment, he takes control of the business entirely. So all the management, their powers cease, because he really wants, he's in charge. He doesn't want to, he still wants to be in charge of all assets. When we talk of assets, we talk of cash at the bank, receivables, physical assets in inventory, whatever. So that these ones, they are preserved for the next stage. If the next stage is to resuscitate the company from intensive care, or if it is to bid a farewell and liquidate it. So in short, I would say that this insolvency administrator will have to do all those processes, of course guided by the law, working with the creditors. There's always an established creditors committee in the first meeting, and then you work with them to see that it builds, the transition, either the company comes back to life or it is finally liquidated. Yeah.
So much. So that means in the say something.
Thank you. Thank you for Isaac for the explanations. He explained more about the responsibility, the role of an insolvency practitioner. But I want to add, to clarify, some technical term or names of those insolvency practitioners. As he said, we have those, I can call them private or independent insolvency practitioners like him and others who are regulated by the Registrar General. But the Registrar General himself, he or she is a chief insolvency administrator who is appointed by the court when it is clear that the asset of the insolvent or the debtor cannot even pay the insolvency proceedings only. And in that case, instead of appointing an independent administrator, the court instruct the Registrar General or nominate him or her to be the the administrator or the liquidator of that particular company, partnership, or an individual. Now, all of them, they are called insolvency practitioners, as the law, the law provides mechanism, proceedings of insolvency, the way we have talked about it, but the law deals with those insolvency practitioners. Now, I want to name them with their specific names when they are in a particular, they are doing particular role. For example, when we are in reorganization, I said the company is under reorganization when it seems there is a chance that the company can be rehabilitated and will not go in the state of being liquidated. In that way, there is the insolvency practitioner who is doing that job is called an administrator, because he is in charge to administer that process. And when the company can't be reorganized, we are going to liquidation, that insolvency practitioner in that particular moment is called the liquidator. Now, when we are, you are not a company, you are not a legal person, you are an individual, you can't pay back your debt, you are an insolvent. As he said, there is a bankruptcy order and you are in a bankruptcy state, you are a bankrupt. The person in charge, the insolvency practitioner in charge of dealing with that process, he is called the bankruptcy trustee. But still he is or she is an insolvency practitioner. There is another type of remedy. We didn't talk much about it. You can find yourself in a state you are not able to pay your creditors, you are in distress, but you don't want to go in court. You can call all your creditors, you do what we call arrangement. You can sit together and see how you can pay back, even if you can't pay all of them, but you have a mutual agreement on how you are going to conduct the process of paying back the loan. You will appoint a person in charge of that process. That person, he or she is also an insolvency administrator, but in that case, he will be called or she will be called a supervisor, meaning an insolvency practitioner will be changing titles according to the particular assignment they are having during the process of insolvency proceedings. Thank you.
So basically, they are all appointed by the court, like after an interested person or the list of the persons that we talked about filed for insolvency proceedings, then the administrator would be changing the name.
For the arrangement, it's normally a private arrangement.
Okay.
That is why it is called arrangement.
Okay.
And for provision one, it can be sometimes the Registrar General can appoint an administrator.
Okay, thank you so much, Leon and Isaac. So maybe if the way you are saying something of provisional insolvency proceedings, and I would like also still to ask you, under what circumstances can the Registrar General institute the provisional insolvency proceedings?
Okay, thank you, Giselle. As we earlier said, normally as a principle, by default, whoever wants to start the process goes to court, has to file with the court. Normally in Rwanda is with commercial courts. And sometimes in case of emergency, we want to preserve the asset of the data for whatever reasons. The Registrar General may appoint a provision administrator to preserve the interest of both creditors in general, of creditors, but also for debtors. It means, and it can also happen when an appointed administrator has resigned. Let's say you were in a process, you were the administrator, for any reason you have resigned. Now in that state where there is, we need, in that transition period, where there is an emergency, we need to preserve something, the Registrar General may appoint a provisional administrator.
Okay, thank you so much, Leo. I think for our viewers, now we have a deep understanding of this law, the proceedings, who are the key players, and you can keep typing in your questions and we'll be answering them. The chat box is open, so we'll be receiving your questions. Isaac, as an insolvency practitioner, Leo was talking about that the Registrar General may appoint the insolvency, the administrator provisionally. Yes, under what circumstances? Maybe if you can talk more about that.
I think as the law said, the the law empowers the Registrar General to appoint a provisional administrator upon application of a party, particularly the creditor. And the Registrar General has to make a decision within 5 days. In my view, the law gave that option to the creditors because it is a shortcut to cutting time to preserve the interests you as a creditor that you have in the debtor. So this is opposed as when you have to file an application to court. You know, when you file an application to court, you just have to go in a queue like any other applicant in court. You do not control, you do not push, you don't do whatever as in court. But the right to file, the right to request or to apply to the Registrar General to appoint a provisional administrator is that shortcut intended to protect, to preserve, for example, the assets. For example, if you come to know that the company who is your debtor is in the process of transferring the assets, yet has not paid you. You know that probably the process of transferring an immovable property will probably take maybe 10 days to complete. So when you apply to the Registrar General, and the Registrar General within 5, and when you say within 5 days, you can take it within 1 day, 2 days. And the law says that the effects of insolvency application via the Registrar General are effective on the day of application. In other words, the day you make application to Registrar General, the effects, which includes staying of any actions against the property of the debtor, they are stayed. Rather than as opposed to court, where the law seems not to be very clear. There we have to be examined whether your claim is valid or not. For example, the law says that the court will admit your application as a creditor if you can satisfy that you have interest in that case. So you can see that there are some admissibility issues which the court must first examine. But when you have to go via the Registrar General, it's so quick. And I think as Anthony said earlier, to me this process of applying through the Registrar General really should instill confidence in investors or even the creditors that their rights will be exercised so quickly, and hence protecting their rights. So now, to your question, why, under what circumstances? The circumstances is that you apply to the Registrar General for appointment of provisional administrator if you know that the debtor company cannot pay the bills on time, or will not. You see now this here there are two. There are two reasons there. One, you are certain that he cannot meet them on time, or he will not meet them on time. But all those reasons have to be within your application, and it's not a matter of just making a statement, but you just have to provide substantive evidence to prove that. So a provisional administrator is appointed by the Registrar General or by the court, depending which channel you have chosen. The court appoints a provisional administrator. The reason why they call a provisional administrator is because it's subject to approval by the creditors in the time what we call administration proposal. So if the administrator, if the creditors committee in their first meeting do not approve you, either appointed by the court or appointed by Registrar General, at that time there has to be another appointment. If you have gone through the Registrar General, the Registrar General will have to appoint another one. And even when it is a court-appointed provisional administrator and the creditors have rejected the appointment because of the reason they have given, the Registrar General intervenes immediately to fill in the gap by appointing another provisional administrator. So provisional administrator transitions from the date of appointment to the approval by the creditors committee. And then you become a fully-fledged now administrator. Yeah. You're welcome.
I think if I understood well, basically the provisional administrator is appointed just still to protect the rights of the creditors and to protect all the people owed by the entity or the entity being falling in insolvency, being insolvent. Yeah, thank you so much. So in the whole process, the way we're saying, of course, there will be disputes. And I would like to ask Anthony, maybe if you can tell us the role of dispute mechanism system in the dispensation of insolvency proceedings.
Yes, thank you, Giselle. So definitely we are talking about business entities. In a business life or in transactional matters between parties, you reach a time where you may have issues or matters that you're not on the same page. So as a financial center, and again, if I echo what I said, the ease of doing business, low-cost perspective, it's also important that among the infrastructures within a financial center, we have these avenues for dispute settlement. So when you look at Rwanda, we have the commercial courts that are doing an excellent job and work, because when you look at the turnaround, compared to many jurisdictions, we don't have backlog here. So that is something that is tremendous that I wanted to point out. Number two, for those that don't want to go that way or the nature of their work or agreements did not provide for that type of forum, we also have the Kigali International Arbitration Center. This is another avenue that parties can go to arbitrate the matter if they so provided. And with the Kigali International Arbitration Center, we have seasoned arbitrators, both international and local. So to say we have it all, if you have a matter depending on the area of expertise or focus, we have all these experts that have arbitrated all these matters. Again, it's also important to point out that we have accredited mediators. As you know, in Rwanda, our court system, one of the mechanisms we undertake, we believe that matters can be resolved when it's still fresh. So we have a mechanism where we encourage mediation. Should it fail, you take either the formal court procedures or you go into arbitration. So all these dispute settlement mechanisms are in place, and they're very important in boosting the financial center. And again, these are some of the areas that inform investors on where to invest and make use of their business. Thank you.
Anthony, so you are basically telling us about the alternatives that people may have. Yes, not like we won't advise people to go to court, but for investors, of course, they won't be having that much time and we know court proceedings, but also mentioning that KIAC is there, so it's an alternative and it works. Yeah. Thank you so much. So my last question to Isaac. Isaac, can you tell us about the procedure of administration of sale proceeds from insolvency?
Yes, I think as I said earlier that one of the objectives of this insolvency law is to manage that crisis where there is a potential of grabbing by each creditor. So the law has set guidelines on how to distribute the proceeds from the data. And I want to say that now this is the time. This distribution comes at the time of liquidation. That means that the companies, all options for revamping the business, dental arrangements, schemes have failed. Now the company has to be put into liquidation. So when it is put into liquidation, there is the law has prescribed the procedures in terms of hierarchy of settling those debts. The first one, of course, as anticipated, is the costs involved in the administration of insolvency proceedings. That's from the date of appointment to the liquidation, to the end of liquidation. Because during the liquidation process, the liquidator or the insolvency administrator at the time of insolvency, time of provisional, then administrator, then liquidator, their costs that are incurred at that time, because the administrator does not work alone. He or she can decide to maintain the existing staff or reduce and maintain some. So those from that time of appointment, those are the wages for those employees become costs of administration. There are costs for those employees. There are consultants that you can have. For example, if you have to hire a property valuer, if you have to get opinions from lawyers, if there are some litigations within that time, you have to hire lawyers to go and represent the data company. Or even when you are sued individually, you can have a lawyer to defend you. So every cost that incurred during that process, including the fees for administrator, they get paid first. Now, if the proceeds are consumed at that level, all the others just wash their hands and go in peace. If there is a balance, the second person to be paid is a secured creditor. But I have to explain here that this time when they say the secured creditor, because there are times when some secured creditors can agree to return some of their secured assets into the. There are some who will say, well, we think that we have the assets which have secured a loan, but according to the value, We don't think that if we maintain them, they will pay us. But we bring back to the pool of the assets of the debtor, probably we can get the best. So now the second on hierarchy is secured creditor. Then there is the third one. When the secured creditor is paid and there's a balance, we go to the one called those creditors that have the right of retention. Now the right of retention, the way they differ from secured creditors is that one, they are not secured because they have not perfected securities. But according to the agreement with the debtor, probably they have their property. For example, let me use this example that you take your car to the garage for repair. But this car, before you could pay back the bill, you fall into insolvency. And you agree at the time of you taking the car, you signed an agreement that you will not, the garage will not release your car until you paid. In other words, the car, it becomes a property to be retained by the garage until you pay. So now the garage has the right on retention of that property. So now this one, they become the third to be paid. After those who have the right of retention, then there is we have the in terms of when you go to the bankruptcy, it may be that during the bankruptcy and management of the bankruptcy estate, the owner dies. So when he dies, the costs for burial and doing the testament, the will and testamentary processes, you as the estate manager, these costs will have to be paid. You have to pay them before others that follow. Now, according to the hierarchy, this is the fourth in the ranking. Then if there is a balance, there is a pension for the employees. They get paid. After pension, you go to the taxes. Taxes, we are talking of other taxes payable to Rwanda Revenue Authority, which is always different from the pension. Rwanda Revenue corrects the pension, but the pension is not tax. It's just they have the role of correction. But some people have been combining the two, pension and the taxes, to be in the same pool. So they are not. So the taxes, they are the sixth in the hierarchy. After pension, you pay the employees. Now, these wages for employees are different from the expenses I mentioned first. Now, these are wages incurred which are not paid to the employees for the last 6 months preceding the insolvency proceedings, the commencement of insolvency proceedings. Now you pay them. If there is a balance, that's when you go to the government taxes. If there is a balance, then you go to unsecured creditors. Now, unsecured creditors, those are the people who have no right of retention, they are unsecured. I would say that they are the last on a list. So when you have a balance, after you have paid all those creditors I have mentioned above, Now the question is, how do you pay? You have 1 billion and unsecured creditors, the total of unsecured creditor liability is about 3 billion. What do you do? So at that time, you apply a principle called pari passu. Pari passu, that's when you say, you make a determination, and that's when that's where expertise of insolvency practitioner really comes in much. Okay, although even the processes are there. The pari passu, you decide that everyone in this class of unsecured creditors will be paid X percentage of their total claim. If your claim, you as an individual, is about 10 million, then you say may have made a determination that everyone will get 10%, for example. That means you get 10% of 10 million. But you have to make it in a very professional and technical way, because one creditor may have like 2 billion. And when under pari passu, if you give him 10%, you imagine how much he's going to get. So he's going to 10% of 2 billion can consume all the. So you have to really see that what is intended there is not that you satisfy all the unsecured creditors, but everyone gets a fair take, and that the best way is to use a percentage. Now, when you have paid all these unsecured creditors, but you have satisfied, that means all unsecured creditors have been fully 100% paid. If there is a balance, you give it to the shareholders, and that's when, like at the burial site, you say, the speaker closes the file. Yeah.
Yeah, thank you so much, Isaac. I think this hierarchy is very important for people to know it, because not every creditor will just come and be like, I'm the first when they're distributing the sale proceeds. Thank you so much.
Actually, maybe before the regulatory element of the insolvency law is really to ensure that fairness that everyone, not those with big muscles, just take it. So it's just to manage that fairness, and someone will not be happy, but who at least will not have a claim to say it was unfairly. Yeah.
Yes, thank you so much. Let me get back to you, Leon. Among the new aspects brought by this new law, there was this the right to supply of essential services. Essential services, yes. And I would like you to explain a little bit to our viewers about that new aspect.
Thank you, Giselle. As you said, one among other new, let me say, provisions of insolvency law, there is supply of essential essential services. When you are in a state of being insolvent and the process has started, as we mentioned earlier, it means whoever is claiming any rights, execution of judgment, requesting the debtor to pay back you the loan, everything is stayed. Even for secured creditors, in case of reorganization, the claims are stayed, all of them. What does it mean? It means when we have started the process and I had to pay you back your 10 million, you will wait until the insolvency practitioner appointed by the court or the registrar general finishes the process of doing whatever it has to do and start distribution of the proceedings from the process. It means you have to wait. That is what it means. But just imagine you owe me 10 million. The process has started of insolvency process, and you say, no, okay, you are not paying me, but don't ask me to supply you again. Let's say I was supplying you, let us take an example of a restaurant. I was the person supplying you beans for your restaurant, and you are not paying me back. Okay, I agree with you. I will wait until the process is concluded, but don't ask me again to supply you more. Do your best and get it. Now you are the liquidator in charge, or you are the administrator in the organization process. For the same example for the restaurant, if you were supposed to pay 10 million for electricity and water. Oh, let me say, what are those essential services? By definition in the law, the essential services are water, electricity, and telecommunications. The three of them: water, electricity, and telecommunications. Now imagine someone who is reorganizing the businesses, his business, and it is a restaurant, and he has a loan for WASAC and ACL for electricity and water. And they are telling that person, if you don't pay first the debt you have with us, we won't supply you more water and electricity. The business will be killed immediately. That is why the law comes to protect that business under distress. You can't oblige someone as a condition before supplying the water and the electricity to oblige the person to pay first the debt incurred before the commencement of the insolvency proceedings. It means when I introduced my case in the court, I owed you 10 million for water. You have to wait until the process is done, and you still have an obligation to supply me water. Maybe I'll be paying for that specific period. Even if I don't pay, the same way Isaac informed us about the hierarchy, the essential service is among priority, is on number one. If you have provided water and electricity or telecommunication during the insolvency proceedings, when all creditors will start to be paid, the essential services is among the number one to be paid. Now, the reason being is, if you don't provide essential, that is what it is called essential. You can't live, you can't operate without water, electricity, and telecommunication in business. That's what it's all about.
Thank you so much, Leo. Yes, saying essential services, meaning if the company or the entity hasn't yet come to an end, it will still need to survive. Though it's going through hard times, but it will need still to survive. So the essential suppliers will have the obligation to supply.
Yes.
And among the hierarchy, as Isaac said, they will be among the first to be paid. Okay. Yes, which is fair enough. Yeah. Okay. Thank you so much.
The supplier can be sure that what he is going to pay after the commencement of the insolvency proceedings will be paid. Yes. But he may not be sure about the previous unpaid bills.
Yes.
Yeah,
so that's why I think the lawmaker put these costs into the first cost to be paid, because because these costs will be paid, there can never be any reason why the suppliers of those essential services cannot continue to provide.
Yes.
And remember this, there's a presumption that they will be paid, because an appointment of insolvency administrator or a provisional administrator is not made. An administrator cannot be appointed if there is no if there's no, if the court is not satisfied that the costs, the assets will be able to meet those expenses.
Yeah. Thank you so much. I think our viewers now understand the hierarchy, understand that maybe if you're a supplier and you are supplying a company going under in insolvency proceedings, and you're supplying essential services, that means you have the obligation to still supply, but also you have the guarantee that while distributing, you will be among the top to be given your shares, if I may say. Yes, as we're coming to an end, I have last question to Anthony. I think the whole process of an entity falling into insolvency, it might be caused by quite a number of factors, but also governance might be one of the issues or the causes. So I would like you to explain to our viewers what is good corporate governance and its role in ensuring entities that are aligned with the concept of going concern. Yeah.
Yes, thank you, Giselle. So corporate governance, these are rules that determine how companies are directed or managed. And as you had pointed out, most of the issues that lead to insolvency, that is where the problem is. So it's important that we take a step back and say, what should good corporate governance be? Now, when you look at corporate governance, it's about how are decisions made. When you make decisions, for example, the board, do you consider interests of stakeholders? Stakeholders, you'll start with your shareholders themselves. You'll start with employees. You'll start with your service providers. And what are the impact of these decisions you make? So these are some of the issues that bring problems. For example, in the past, you've heard of the Enron case, how these affected the company and it ended up into bankruptcy. Then you also talk about issues of financial audits. Is there transparency in the financial audits? Or you're keeping something under the carpet? So when you look at that, it's a big element that brings down companies. Again, are there any possible conflict of interest? Okay. As a director, do you have the company at heart? You owe it a duty of care. How do you manage that? So these are aspects that I believe when we talk about insolvency, companies out there, boards, they should consider this. And again, it's also critical to understand the field you're in and to also see which is the type of skills that you need from those directors. Sometimes directors sit on a board of a company and they don't have the requisite skills in relation to its mission and why it's in place. So definitely you make the wrong decision. So it's about accountability. Let this continue to be an area of discussion, and definitely it will be one of the, for me, the game changers in avoiding insolvency problems for most companies. Thank you.
Thank you so much. Thank you so much, panelists. Yes, the law is big, but we've shared it through our social media, and you can still, our viewers can still access it if they want to read more and gain a lot about this new law. And for us, we are also still here for you. You can still reach out to us through different institutions, and we can still give you more insights or clarifications. So thank you so much. Now it's time for questions. You can see you have some questions here. The first question is from Wycliffe Nagawa, who said, thank you, our panelists. His question is whether a liquidator appointed in Rwanda can attach assets located in a foreign jurisdiction. What are the legal and practical considerations? I think this is open to the panelists. Whoever wishes can take it and answer it.
Well, let me answer the first question. The question here is whether the a liquidator appointed in Rwanda can attach assets in a foreign jurisdiction, and what are the legal and practical considerations? The first answer is yes. Remember, we come back to what Anthony said, that under the cross-border insolvency, Rwanda has recognized, and this is the general, and this is a universal, almost universal principle, that the center, the place of the center of the main business will lead, okay, or will lead and take, will prevail over all other operations of that company in other jurisdictions. So if you are appointed as a liquidator in Rwanda, first there is a presumption that probably either you are liquidating a company that has the main seat and operations in Rwanda, or you are appointed to liquidate a subsidiary of a foreign company. So depending on which, whether if the company you are liquidating in Rwanda has its main seat and operations in Rwanda, is the main center of the business, yes, then you are empowered under the cross-border rules to attach the assets in the foreign jurisdiction. If you are appointed to liquidate a subsidiary in Rwanda, then the rules on the center, on the main center of business will apply, because remember this is a subsidiary. You first look at what are going to be the effects of subsidiary to the main center, out of the parent company. So you just have to look at this. But as a general principle, yes, you can attach if you have that overall powers to recover and sell and distribute.
So I just wanted to also supplement on what Isaac has said. The principle is yes. However, there's one more step to go. One is that you would have instituted proceedings here. So if you're going to be successful in attaching assets in foreign jurisdiction, you have to also go through the procedure of recognition of these proceedings, and you fulfill the requirements in those foreign courts. Once they're recognized, then the yes becomes practical enough. So I just wanted to bring that in context. It's not just a right or possibility, but there are also those procedures of recognition of that court. And once they ask you for all these judgments and evidence, then once they recognize, then you can attach. So that's what I wanted to add.
Yes, thank you so much. You want to add something else? Okay, thank you so much, our panelists. And Wycliffe, I think you understood what they've been explaining, that it's doable, it's possible. The answer is yes, though in another jurisdiction you can't just go there and start executing. You just need recognition in those jurisdictions. And his second question is about would the liquidator appointed in Rwanda recognize and enforce security interests on Rwandan companies' foreign assets if they are registered with a foreign registry and not in Rwanda?
Okay, thank you, Giselle. Thank you, Nagaba, for the two questions. I think the question number 2 relates to question number 1. It's their issue of recognition, as Isaac and Anthony said, in order to execute or enforce any decision from Rwandan jurisdictions in foreign country, you have to start the process of recognition in that specific foreign country. That is, the response was yes. For question number 2, by default, the response is no. As a principle, is a matter of principle. You cannot execute or enforce or seize any asset which is not located in Rwanda when you are appointed as a liquidator in Rwanda. You may record that. Let's say you are conducting insolvency process of company X registered in Rwanda. Your competence is limited to the territory of Rwanda. You will be seizing, you will be doing the inventory of assets of that company registered in Rwanda. Where he says enforce security interest. Security interest is one of a movable asset. It's a guarantee. It's a security, but which is a movable asset, not immovable. It can be registered in Rwanda, in RDB with the Registrar General. It is enforceable in Rwanda. But for those foreign assets which are not registered with, which are registered with a foreign registry, let's say in Uganda or Kenya, a liquidator in Rwanda cannot enforce it. It's no, as a principle. But exceptionally, the same liquidator can go in that particular country and also request for recognition of the process which started in Rwanda. Then it will be enforced in that particular country, and it will depend also, there's another aspect of reciprocity. We can't go to any country to enforce our own judgment if we don't have such agreement, or it does not exist in their laws. For example, in Rwanda, this is new in our legislation. If this would have happened in 3 years back, it wouldn't be possible. That you have to check if in that respective jurisdiction it is provided for. The response is yes and no. It depends on circumstances, it depends on the country, it depends on their local reality and jurisdictions and their laws.
Yes, thank you so much. I think it's clear.
This question, the challenge that this question has is that, one, is that these assets of a Rwandan company, they are already registered in a foreign jurisdiction as security interest. So if they are already in a registry abroad, that means there is an interest why they have been registered there, either for the lender or whoever. But that means for the fact that they are in a registry, that means someone has a security interest on them, or has another type of security that he has on those assets.
Okay, thank you so much. I think Wycliffe, your questions are answered, and I would like now to thank our panelists who gave us very engaging discussions and really provided deep understanding to this law, and it was really needed for our viewers. So you can still reach out to us. Yes, we didn't go on each provision of this law. Other questions you may have, you can reach out to us, Rwanda Finance Limited, or RDB, or even Lex Chambers. Thank you so much, and have a nice day.
Thank you.
Thank you.
Thank you.
The mandate of the Minister of Finance and Economic Planning is to manage the national economy and to ensure macroeconomic stability and economic development. The Kigali International Financial Center plays and will play a great role in our Vision 2050.
Kigali International Financial Center has been created to promote Kigali as a platform for financial innovation and financial investment in Rwanda, but also across Africa. And it has had a very good start and been able to attract a number of noticeable players already, and is continuing to do so.
The Kigali International Financial Center is coming within a context of rapid economic growth in Rwanda. Today, if you want to do business across the continent, we offer you Rwanda as a hub. You come here, you set up your business here, and then you can expand to the rest of the African continent.
In terms of untapped opportunities in Africa, we have access to expand. Yeah, we have a very large untapped market, can be catalyzed by technology today. Africa has the highest mobile penetration. That is in itself a really good opportunity to transmit those financial services.
We are in the middle of the digital transformation. We have new ways how to interact with finance, with our fingertips on our smartphones. In the financial industry, we call it fintech, financial transformation. This kind of trends, we have a big impact in the future.
Fintech is a key component of what we want to do in Rwanda, and that will have positive externalities for Rwanda, but also for Africa.
There are certain areas that require our attention in society where we haven't solved problems. And the one is financial products for young people, where you don't necessarily require collateral and where someone's financial background doesn't play a role. As an organization and as a founder, I believe that you need to stay as close to impact as possible. That's why our headquarters are based in Rwanda, because most of the students that we finance are based in Rwanda. So it's natural for us to want to base our fund in Rwanda.
One of the advantages investing through KIFC has is having those DTAs with fellow African countries helps to ease, business entry from Rwanda to the rest of Africa. And having a young team of professionals whose single focus is to help you set up your business has been one of the most beautiful experiences I've had worldwide doing business.
One of the critical factors here is having a credible framework that the market will accept. We mean the right laws, we mean the right regulations, we mean the right approach to compliance, and Rwanda at great speed are passing these laws, and that's very encouraging to see.
When it comes to Africa is a growing market. Now recently 55 countries of Africa have decided to embark on the continental free trade area, which is the largest globally. And this makes even more attractive Africa as a destination for investment.
This is a game changer for the continent for a number of reasons. First, there will be increased focus in the trading of value-added products and services. There will be the benefit of comparative advantage as well between countries. There will also be the benefit coming from the fact that intra-African trade transactions will be settled in local African currencies.
The financial sector plays a key role in the functioning and the development of any economy. That is the place where people who are innovators and entrepreneurs and who need capital meet the providers of capital. And there can be no economic growth, no successful businesses if that connection is not done effectively and efficiently.
Financial innovation is key to unlocking sort of our economic growth on the continent. And the fact that Rwanda is leading that is again showing how it's being sort of a beacon of light around financial innovation. Making Rwanda a financial center will have a significant impact for the region.
This is Africa's turn, it's happening, and the financial services is at the heart of that. It's the lifeblood, it's the heart, it's the lungs. I mean, any metaphor or analogy you can take, financial services is indispensable to finally lift Africans out of poverty, provide them with the jobs they need and the prosperity they need.